In recent days, a disquieting chapter has unfolded in the intersection of politics and law. The Trump administration, embroiled in a series of legal setbacks, has resorted to an unconventional tactic by issuing executive orders aimed at pressuring prominent law firms. This investigative report examines the emerging pattern where these legal entities are either coerced into capitulation or stand firm in the face of political intimidation. The controversy centers on executive actions that target the very professionals tasked with upholding the rule of law. Specifically, two of the nation's most established law firms, Jenner & Block and WilmerHale, have taken a resolute stand by challenging these orders in the courts of the District of Columbia. Unlike some of their peers, these firms have not hesitated to confront the administration head-on, filing lawsuits to defend their independence and professional integrity. Their actions serve as a stark counterpoint to the recent settlement reached by Paul Weiss, a decision that has since drawn widespread criticism within legal circles. To fully appreciate the implications of these developments, it is necessary to consider the background of the matter. The Trump administration, facing mounting legal defeats over a series of controversial policies, appears to have shifted its strategy toward the legal profession. By targeting law firms with executive orders, the administration aims to dissuade legal challenges that have been mounting against its policies. This move represents a direct attack on the institutions that are critical to ensuring accountability and transparency in governance. The actions of Jenner & Block and WilmerHale stand as a testament to the growing resolve among legal professionals to resist such politically motivated interference. Both firms, known for their long-standing reputations and extensive practices across major cities like Washington, D.C., New York, Chicago, and Boston, have quickly mobilized. Jenner & Block and WilmerHale's lawsuits challenge the legitimacy of the executive orders that not only jeopardize their operational independence, but also undermine the broader principle that legal counsel must be free from political coercion. Their legal filings articulate a clear message. Intimidation will not substitute for genuine legal argumentation and due process. In contrast, the settlement by Paul Weiss with the Trump administration has sparked significant debate. Critics argue that by choosing to settle, Paul Weiss has compromised its commitment to justice and set a dangerous precedent. The settlement, which included an obligation to provide $40 million in pro bono legal services for causes that align with the administration's ideological stance, has raised profound questions about the balance between financial expediency and principled legal advocacy. In the eyes of many within the legal community, such an arrangement not only represents an abdication of professional duty, but also potentially diminishes the availability of legal representation for those who cannot afford it. This divergence in responses among major law firms has broader ramifications for democracy and the principle of equal access to justice. At its core, the issue transcends partisan politics and touches on the foundational role of the legal system in safeguarding democratic processes. When law firms are compelled to align their practices with the demands of political power, whether through capitulation or through settlement, the risk emerges that citizens will lose access to impartial legal counsel. Many of these firms commit substantial resources, often amounting to tens of millions of dollars, to litigate on behalf of causes that might otherwise be marginalized or ignored. A reduction in such litigation would not only embolden the administration in its legal strategies, but could also erode the legal recourse available to citizens wronged by governmental actions. For many, the broader concern is that legal professionals who choose to yield to political pressure do so at the expense of the integrity of the legal system. The decision by Paul Weiss to settle, as opposed to standing up against the Trump administration, is being scrutinized for its potential long-term consequences. Legal experts argue that when prominent law firms surrender their autonomy under duress, it undermines the essential checks and balances that hold political power accountable. In contrast, the firm stance taken by Jenner & Block and WilmerHale is being hailed as an act of courage and a reaffirmation of the legal community's commitment to democracy. Beyond the ideological and democratic implications, there are also significant market and reputational considerations for law firms. In an industry where reputation is paramount, the choices made by high-profile firms have a ripple effect. Enze. Recruitment is one area that stands to be impacted. Young lawyers and law students are likely to favour firms that demonstrate a commitment to ethical principles and a willingness to engage in robust legal defence of the public interest. The spectacle of a firm like Paul Weiss negotiating with an administration known for its aggressive tactics may tarnish its image and deter new talent. Conversely, the resolve shown by Jenna M. Block and Wilma Hale sends a powerful signal to prospective hires and clients alike. Integrity and courage remain prized values in legal practice. Clients who find themselves pitted against government agencies or politically powerful entities are especially sensitive to these dynamics. For individuals or organizations seeking legal representation against the Trump administration, the credibility of their counsel is crucial. A firm that has proven its willingness to challenge political pressure is likely to command greater trust among those who feel marginalized or intimidated by governmental overreach. This trust is not merely symbolic. It translates into effective legal advocacy that can hold authorities accountable and ensure that justice is not sacrificed at the altar of expediency. This strategic targeting of law firms by the Trump administration, particularly through the issuance of executive orders, must be understood as part of a broader pattern of behavior aimed at suppressing dissent. When government officials or affiliated groups engage in what can be described as legal intimidation, they risk undermining the independence of the judiciary and the legal profession. This trend, if left unchecked, could lead to a situation where the administration's victories in the courtroom become less about the strength of legal arguments and more about the ability to coerce and compromise independent counsel. Legal analysts note that the underlying message behind these actions is clear. If law firms do not conform to the administration's expectations, they may face significant professional and financial repercussions. This creates an environment in which the fundamental principles of legal representation are subordinated to the demands of political expediency. Such a scenario is not only detrimental to the legal community, but also poses a threat to the democratic process as a whole. In a climate where political power increasingly intersects with legal practice, the repercussions for democratic accountability are profound. A judiciary that is unable or unwilling to challenge executive overreach is a judiciary that risks becoming complicit in the erosion of civil liberties. The willingness of law firms like Jenner and Block and Wilma Hale to confront these pressures head-on is therefore critical, not only for their own reputations, but for the broader principle that justice must be administered without fear or favour. As this situation continues to evolve, it is essential to keep a vigilant eye on how the legal community responds to further attempts at coercion. Recent reports indicate that another New York law firm may have preemptively sought to negotiate with the administration, potentially setting a new benchmark for capitulation. Such actions, if they become widespread, could fundamentally alter the landscape of legal advocacy in the United States. The contrast between those who stand up and those who yield will shape public perception and influence the dynamics of legal representation for years to come. In conclusion, the targeted actions against law firms by the Trump administration are not isolated incidents, but rather part of a concerted strategy to weaken the mechanisms of legal accountability. The bold moves by Jenner and Block and Wilma Hale in rejecting these executive orders and fighting back in court offer a glimmer of hope that the legal profession will not be subservient to political intimidation. Their stance reinforces the vital role of independent legal counsel in ensuring that democracy remains robust and that every citizen, regardless of their financial means, has access to fair legal representation. This report underscores the importance of resilience and principled advocacy in the face of political pressure. As the legal community navigates these turbulent waters, the choices made by leading law firms will have lasting implications, not only for their own futures, but for the integrity of the democratic system itself. The call for continued vigilance is clear. The preservation of justice depends on a legal profession that is unafraid to confront power, regardless of the consequences.